Court case we're staying on today, the Meyiwa murder matter, back at the Gauteng, North Gauteng High Court this morning. Forgive me, Meyiwa, the former Bafana goalkeeper and captain, gunned down almost 8 years ago, can you believe it, at the home of his girlfriend Kelly Khumalo in Vosloorus. Slendelo Masakane, eNCA reporter at the court for us. Also going to get the thoughts of Marius du Toit, legal expert, in just a moment. But first, Slendelo, let's come over to you just outside court. You were saying earlier that while it does seem to resemble a resumption, no witnesses in court today. Hi, Slee, why is that?
More of an administrative session that we're going to see taking place here in the North Gauteng High Court when the proceedings resume at around 10 a.m. this morning. During our last sitting, we had an indication, of course, from Advocate Mshololo that, one, she needed time to peruse the second docket into this matter, that's docket 375, as well as get clarity from the NPA in terms of whether it plans to prosecute that particular docket, as well as how it affects, of course, her clients. And so we had a lengthy then postponement that was agreed upon between counsel, and we were expecting, of course, the trial to resume in September with the state's first witness back in the witness box for cross-examination by Advocate Mshololo. However, Advocate Diffo for accused 1 to 4 then indicated that, firstly, he wanted to argue jurisdiction, and what we were going to see taking place today were the arguments after papers had been filed by counsel in terms of his issue around the North Gauteng High Court presiding over this matter. However, he made a U-turn a couple of days after we had adjourned, indicating then to the court that he wouldn't be filing jurisdiction papers, but rather than writing straight to the NDPP to have charges against his clients dropped, because he believes that there is no case against them, firstly, but also that in fact the state should be prosecuting docket 375 that accuses Kelly Khumalo and those who were in the house as being the ones who have a case to answer to. So today what we are expecting is that Advocate Diffo would have received possibly a response from the NDPP following his letter, and exactly what the way forward then is going to be and how it's going to affect this particular matter. So we resume at around 10 a.m. this morning, but no witnesses going to be called to the stand, just counsel that is going to be in court and updating really the judge as to what has transpired since that letter from Advocate Diffo to the NDPP.
Legal expert Marius du Toit also joining us this morning. You can see Marius there joining us via Zoom. Hi to you, Marius. Good to have you with us. So just unpack that for someone like me who might be struggling to follow this. Slendelo making a very good point. Advocate Diffo, first of all, wanting an application to argue jurisdiction, changing almost a U-turn, now going about a change for docket 375 and wanting reaction from the NDPP. Interpret that for me. Why follow this line of legal action?
Well, it's a mystery to me as well, Gareth. Let me just say this. In terms of the Criminal Procedure Act, should you feel that there's no merits to prosecute you, the state can at any stage stop the prosecution against you. They call it a stay of prosecution. But that would have the effect of an acquittal. So at the end of the day, I can't see the state reneging on the fact that they prosecuted them in the first instance and now suddenly saying, listen, we don't want to prosecute you anymore. I don't see that happening. In respect to the jurisdiction, I think the point he had that the court did not have jurisdiction was bad in law. I think maybe he spoke with his colleagues and maybe abandoned it on that basis, because the Joburg and Pretoria courts have concurrent jurisdiction in the same division. If it's a magistrate's court, that would be a vastly different story, because each magistrate has its own magisterial district. But the High Court has concurrent jurisdiction between Joburg and Pretoria, and it's a matter of convenience that the matter is heard in Pretoria. So I don't see any problem with that. The stopping of prosecution, Gareth, I can't see that happening. Let me do say this, though. The fact that a new docket has surfaced that suddenly fingers Kelly Khumalo in the murder is embarrassing for the state. The state has to make a full disclosure before the trial starts of all the evidence they have in their possession, which could assist the defense in their preparation of the trial and, of course, in cross-examination. The fact that this was disclosed at a late stage prejudices without a doubt the accused, but that's why there was a delay, and that's why the matter was postponed, Gareth, so that there was time for them to work through the docket and say, fine, we've now done that, now we can cross-examine the witnesses based on this docket.
And yet we're still seeing delay after delay in the court case proper itself, as Slee mentions, Marius, only resuming in September. Does this seem to be unusually long delays between court appearances? Last question to you before I go back to Slee.
Yeah, I think we have to remember, Gareth, that the court rolls are congested, especially the high courts. So you have a judge that's now seized with the matter, so he has to conclude the matter. At the end of the day, this judge is in control of the proceedings, even though the state is what they call in Latin terms dominus litis, so they're in charge. But the judge can direct how the proceedings should take place and what should happen. And I think this was just the judge saying, listen, we've got an issue here. Let's sort out the issue. Let's not waste the time of the witnesses to wait in the corridors and frustrate them by waiting whilst we sort out these peripheral issues to the trial. And once we've sorted out, we can reconvene in September. So I don't see anything untoward about the delay. Unfortunately, in the High Court, you tend to get longer postponement. If the matter, usually what they term in the High Court is they've got a continuous role, which usually means when you start, you have to finish. But it can happen that due to stoppages like this, that they have to postpone and reconvene at a later stage because it's simply not possible for the matter to continuously be dealt with. And so there's nothing untoward about it. And in September, hopefully, we can have the matter continuously proceeding.
All right, Marius du Toit for the moment. Thank you very much for joining us, legal expert, bottom right of your screen. So, Slindelo, as we come back to you again to just wrap things up, previewing what we're expecting later, you said court, remind me, expected to get underway at what time this morning? And by the sounds of it, administratively, there shouldn't be a very long day in court. As Marius suggests, it all should be fairly done and dusted and discussed.
So we started around 10 a.m. this morning. We know, of course, that due to the nature of court proceedings, Gareth, that could change at any moment, depending on whether we also have the accused brought here on time. But if counsel arrives in time, the judge is here, the accused are here, then we will certainly start at 10 a.m. this morning. We will be bringing you those visuals live from the North Gauteng High Court. And I can't say whether it will be a short session, Gareth. Like I say, court is very unpredictable. This case has been very unpredictable itself. So whether it will be a short session, I think remains to be seen. But our viewers can expect proceedings to start any time from 10 a.m. this morning.
And we look forward to it as always. Lindelo Masikane, thank you very much. Quite right. How long is a piece of string? Who knows how long court will be in session today. But as Slee says, no witnesses in court, an administrative day. But that's not to downplay the importance of today.